that you were speaking about earlier, David, is necessary. It's necessary for us to spread hope. And the hope that we have is by being together in this environment of shared interest for a dream, that one day we shall certainly overcome cheating in sport. And I think it must be very difficult for people who espouse to truth and fairness as shared values across the globe to find that there are people who, for whatever reason, particularly financial gain, use whatever opportunity that comes their way to secure advantage over others. And we have in this society seen that advantage of that disadvantage being overcome through what was previously advantage written into the law. And that's the challenge for lawyers, is to use the law as best we can within particularly the South African context of the constitutional framework which guarantees basic human rights, particularly access to the law, and then of course the fact that those rights will be measured in the interests of that emerging society, what is in the society's best interests. So the challenge for us today is to look at the decision-making process as panel members, and for that I'd like to really thank those panel members who I've been involved with publicly. I think the chairpersons seem to get all the kudos and they get the front stage and the podium, but it's those backstreet people who support us as chairpersons in developing understanding, particularly in those areas where we have no understanding, particularly Bev, Joa, Cello, Greg, Nzwaki, William Newman, Nazir and others who've been amazing for me and the panel in supporting us as we reach decisions on a consensus-driven basis. So Khalid wanted me to look at how we develop a framework for decision-making, and after yesterday's two presentations by Alan and Andrew, and then a presentation by Adam today, it's very nice to follow as B for Bush in this development. And I was hit by what was on the toilet door in the men's loo yesterday. If you've seen that inscription about Bush, I must issue a legal disclaimer immediately. Name yes, association no. Maybe through the Genome Project I'll find out one day. But as we move into the process, the structure that we look at, essentially the SAGE rules set out the structure. We debated yesterday as panel members whether or not that structure was properly constituted, and we do have some work to do there to ensure that we follow the rules, I think, with regard to ensuring that the committees are properly constituted, possibly in terms of a mandate issued by, under the current rules, either the chairman or the vice chair of the overall committee, the disciplinary committees as we see them in the rules. So having been properly constituted and properly composed of at least a lawyer and a medical person and an administrator or sports person, we go into this forum with people, and we ask the so-called accused, the athlete who faces the adverse analytical finding, to bring with him or her all the papers and witnesses that they may need. Yesterday we were reminded that the committee has the right to make contact with the accused, and clearly the accused attorneys. The infringer of the right is probably a better word. I think the accused sounds to me more like a criminal case. This isn't a person who's infringed a competition rule. And the sense of criminality, yes, might be there, but for me as a lawyer, it smacks of almost a derogatory approach to undermining what is really the principle of sport, that we will play fair, we'll play according to the rules. So let's not introduce too many words that suggest an individual is a criminal or an alleged criminal before we've reached a decision. So yes, he or she has the right through that process to make it known to everybody what their case may be and what witnesses will be brought in. And the reason for that is clearly not to be caught by element of surprise when the hearing takes place, when it takes place. And clearly the rules say that the hearing has to take place within a particular period, and decision has to be reached. You may be able to deliver the decision extempore at the hearing, and thereafter provide written reasons. And there are all sorts of time periods. My experience has shown that practically the time periods are there, but in essence they don't necessarily work, because we seem to be moving out of those time constraints. And perhaps that's another issue which we could resolve, is how more efficiently could we operate within the decision-making process, particularly where athletes today are bringing on legal teams who for various reasons are not available because they have other pressures. Okay, so now we have this practical position where people have arrived at the hearing, we have no surprises, and now we have a process. I think the process is pretty clear in terms of the rules. The procedure is our own procedure. I think it's incumbent upon us as panel members to make it clear to everybody there what we're about. After the introductions, explaining the process or the procedure, possibly beforehand in any kind of pre-trial or pre-hearing situation, so that people are not themselves caught by surprise, particularly those unsophisticated people coming in for the first time from outlying areas who've never been in such a daunting place or forum. So, not being caught by surprise ourselves as panel, the infringer of the right legal team discuss and accept that this will be the procedure. Now, we've spoken yesterday about inquisitorial and accusatorial approaches. I think we are undermining the process in some ways. I think too much leeway is given the prosecution in perhaps introducing an inquisitorial approach without defining that up front. And I would suggest that in terms of the rules, the prosecution has to present its case. And the point was made yesterday that the case hinges upon the results. And the fact that currently people are not necessarily disputing those results up front lends itself to a process where currently we don't have to bring in a witness to deduce that evidence, to bring it forward and say, well, do you accept this or don't you? So in a way, what we should be doing up front, I think, is agreeing that we'll have a kind of informal pre-trial process. The prosecutor and the defense team, defendant himself, the infringer of the right, will say, this is what I'm prepared to admit. And I think we've adopted that process up front to curtail or limit the duration of those proceedings. And it's worked well. And I think Nick might want to comment on that later. But what happens is, very quickly, we get all the papers up front, all the documents upon which SAGE is to present its case as the prosecution, and we get admissions. And very quickly, we see that in most cases, in fact, in I think almost every case that I've been involved with but one, we've had the admission of the infringement, and we have the acceptance of the adverse analytical finding. So immediately, one can mark down, in terms of the process, a breach. Guilt, another kind of criminal word. Maybe our language could be a little bit softer. Process then continues, and of course, if I can just move. This is the approach that I'd like to see adopted in a more structured approach. Of course, courtesy goes without saying, in terms of our respect for each other, and that goes within the panel itself. So we look at the panel composition, and we see that between ourselves and between the infringer of the right and the team, we see consensus around a lot of issues. We want complete understanding. And I think that's where we are both hunters and gatherers at the committee level of information. And that information is evidence. And unless that evidence is led properly, not on an informal basis, perhaps necessarily by swearing in. The suggestion was made yesterday that we do have a formal swearing in process of every witness. That might be something that we need to tie into a framework or a template for consideration.